All right. We are live, yes. I'm just going to skip it. Yeah. Okay. All right. Well, good afternoon, everyone. Today's Monday, March 14th, 2022. We have 1, 2, 3, 4, 5, 6, 7, 8, 9 bills on the voting list. We're going to start off with a couple of re-referrals, bills that were improperly assigned to the Judicial Proceedings Committee. What is the motion for a re-referral? Motion for a re-referral?
Yep.
All right. So for Senate Bill 958, these are all pension bills. These are both. These are both pension bills, 958 and 997. The motion is to refer them to budget and tax. Is there a second?
Yeah. Second.
Excellent, everyone's good. All right. Now,
I've never seen that done for a committee.
neither have I. Now, next up, we'll go with Senate Bill 662, which is the Access to Counsel Eviction Special Fund. That was jointly assigned to budget and tax. They sent over an amendment, a technical amendment. Heather, could you explain?
So there's not an amendment in your packet, so I'm just going to orally read it aloud to you. So it says, for fiscal year 2024, the governor shall include in the annual budget bill an appropriation of $14 million from the fund to MLSC. So it's not giving an additional $14 million, it's just taking the $14 million that you already voted to approve under this bill and directing it to MLSC in the bill. Yes, it needs to be adopted. It's already been adopted by B&T.
Motion is to adopt the amendment. Seconded. Everyone's okay? Great. Do we need to re-vote the bill?
Yeah.
All right.
So favorable with amendment?
Yeah.
Favorable with amendment. The motion is for favorable with amendment. It's been seconded. Everyone's good. Excellent. All right, next we're going to go to Senator Waldstreicher, 875, and that is Josh.
Senate Bill 875 elevates citizenship and immigration status to protected classes for the purposes of state fair housing laws and prohibits discriminatory practices in residential real estate transactions and the sale or rental of dwellings because of a person's citizenship or immigration status. In connection with the rental of a dwelling, the bill also generally prohibits a person from inquiring about, disclosing, or threatening to disclose a person's citizenship, immigration status, or national origin, unless specifically required by a state or federal law or a court order. The bill does not prohibit requesting information or documentation as part of a standard rental practice to verify financial qualifications or the identity of a potential renter if the same information or documentation is requested of every potential renter. There is an amendment in your packet that is number 983821/1. The amendment adds definitions for the terms citizenship, immigration status, and national origin. And it also adds responding to a law enforcement inquiry that is part of a criminal investigation to the list of exceptions to the prohibition on inquiring about citizenship, immigration status, or national origin.
Let's go ahead and adopt the amendment first. So there's a motion to adopt the amendment. It's been seconded. Everyone's good with that. All right. Now, the bills before you as amended. Discussion. So there's another forthcoming amendment. Senator Lee would like to be added to the bill. You could probably just do that on the fly. Discussion.
This has the Maryland multi-housing amendments.
Yes.
Okay.
Roll call. Do roll call. All right. So the motion is for favorable.
Why don't you explain it, please?
Do you want to explain?
Look,
All right. I got it.
I mean, this doesn't limit you by the size of the property. This is all properties. And if someone's going to be leasing their house or a part of their house, they have a right to know who the heck they're leasing it to. And if they're in the country illegally, they have a right to know that. And if they choose to lease it, that's fine. But I don't think we're the state could come in and tell people how they can lease their property, rooms in their house and the like. So I don't favor that.
Can you discriminate against on the basis of race in leasing your property?
No.
No. So this
This
just
isn't a
says
discrimination.
immigration status.
This is simply an immigration status.
All right, there's been a motion for favorable with amendment. It's been seconded with amendments. It's been seconded. We'll just do a roll call.
Vice Chair Wildstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
No.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes. All right, we're gonna go with Senate Bill 92 next.
So with Senate Bill 92, there is an amendment in your packet. So the bill as amended is amended to be identical to the House version. This is the same bill that we received the bill hearing on. So the bill as amended, it repeals the current section in Maryland Code on partition of real property and replaces it with a new subtitle based on uniform partition of property. Of real property. So the bill sets forth procedures for the court to follow, including, for example, to first determine the fair market value of the real property and set the procedures for the different tenants to elect partition by sale and how the other tenants will be notified that partition by sale has been elected, and step by step goes through the procedure that the court is to follow in a partition action.
Quite the amendment. It's a rewrite, it's like a whole new bill.
Yes.
Senator Cassidy.
Yeah, I was concerned on this one, and it came before us before, because it did look fairly complicated, and I had asked whether the Bar Association had a chance to weigh on it. I was able to sit down today with the Bar Association's real property section. They do favor the bill. It does provide needed relief. These are complicated matters on properties that end up with a lot of different family members owning the property, having an interest in the property, and then, you start off with 3 brothers on the property, and 50 years later, you have 37 relatives, some of them who aren't in the country and all over the place, owning the property, and now you can't sell the property because you can't get everybody's signatures. It becomes really convoluted. So this resolves those issues. So it is complicated, but I think that the support by the real property section of the Maryland Bar Association gives me great comfort. So I now support the bill. And I appreciate the sponsor giving us, and the staff giving us time to look at this and get more comfortable. So, but I feel comfortable now. Thank you.
In addition, the Maryland Realtors are in support of this bill, and important to me, the Uniform Law Commission, the National Conference of Commissioners on Uniform State Laws, sent us testimony strongly supporting the bill. It's important that if we have these uniform laws, that we continue to march forward in a uniform way with the other states. Otherwise, there's no point in having uniform laws in the first place. So I support it.
Thank you. I've told the senator that I was extremely grateful that he had put this bill in. It's something that the transitions from property, and air property has been certainly an issue within for the black community for decades, and a number of families have lost property because of the way the law was, and someone's ability to swoop in and get a portion of land and essentially take property from families in that matter. So I would ask that after this, if this bill is passed, that I'd like to be amended on as a co-sponsor.
No, certainly some of the most compelling testimony that I've seen this session. All right, can we adopt the amendment first? So the motion is adopt the amendment, everyone's okay? Great. All right, another amendment is that Senator Sidden or Senator West, Senator Heddleman would like to be added on. All right, so that's another amendment, everyone's okay? Great, now the bill is before you as amended. The motion is for a favorable unless there's further discussion. It's been seconded.
Favorable with amendment.
Favorable with amendments. We got sponsor amendments and we got this giant amendment. All right, bill passes unanimously. All right, we're gonna go on to Senator Carter, Senate Bill. This is, 53.
Senate Bill 53, subject to an exception, prohibits a law enforcement officer from conducting a custodial interrogation of a child until the child has consulted with an attorney and the law enforcement officer has made an effort reasonably calculated to give actual notice to the parent, guardian, or custodian of the child that the child will be interrogated. On Friday, the committee adopted an amendment, which you have in your packet, which is number 753022/1. So just to remind everyone, the amendment changes the title to the Child Interrogation Protection Act. It makes some modifications to the exception relating to public safety. And it allows the state to overcome a presumption that a statement is inadmissible if it was obtained in violation of the bill's requirements by showing by clear and convincing evidence that the statement was knowing, voluntary, and intelligent. And it also clarifies that that presumption of inadmissibility does not apply to bar the admission of the statement again in a proceeding against another individual besides the child who made the statement. I believe there's another amendment that's going to be proposed to the amendment.
All right, Senator Carter, you want to speak on it, or do you want to, what do you want to do?
Well, I'm not sure if we discussed the two kind of sticking points for the bill, and I thought we had some potentially agreed upon language, and the two amendments that we talked about centered around custodial interrogation and the public safety exception to Miranda. And I believe that what we concluded was that we should stick with the judicially recognized definition of custodial interrogation as the Supreme Court and Maryland courts have decided, and I don't know if we have amendments drafted, but the bill already did speak to that. With you want to finish?
No, I think let's just take it one at a time, because those
Okay.
are two major points of contention, so.
They decided not to move on the other.
No, yeah, I understand, but let's start with custody first. We'll work our way down.
Yeah, I mean, there was no. Yeah, so the bill currently applies to custodial interrogations, and the bill retains the judicially defined definition of custodial interrogation, which requires that an individual be in custody, meaning that under the totality of the circumstances, a reasonable person does not believe that they have the right to leave that situation. And then there has to be interrogation, which requires that there is questioning, which is designed to elicit an incriminating response. So the way that works, the judicial definition works, is that's an objective totality of the circumstances kind of test. So you take into account a number of different scenarios, including, these have been articulated by, the Maryland courts, when and where the questioning occurs, how long the questioning occurs for, the number of officers who are involved, what was said during the questioning, whether physical restraint or something equivalent to physical restraint is used, whether the person is being questioned as a suspect or a witness in the case, how the person arrives at the place of questioning, and what happens after the questioning concludes. So those are some of the factors that courts would take into account when they're determining whether a particular situation constituted custodial interrogation.
Senator Cassidy.
I thought what you discussed last week, Josh, indicated that there was some additional concerns for juveniles I mean, what you just, the factors you all stated I can see them quite clearly in the case of a 30-year-old adult. But is that exactly the same case law for juveniles?
Yeah, so the test is an objective one. It's not based on the nature of the person who's under questioning. I think where some of the special factors for juveniles might come in is when you're considering, for instance, where the interrogation occurs for a juvenile. That might be at school, so that would affect the reasoning. But it is an objective test that applies the same no matter who the person being questioned is.
So you're telling me that when the court looks at the 18-year-old with a limited education who doesn't speak very well and is partially deaf, that they'll still say, oh, this is an objective test, and a 40-year-old person who's got a high school diploma and speaks English fluently with good hearing, that's what we're going to judge it by? I'm sorry, that's just not going very well for me.
In terms of whether it is a custodial interrogation, it is objective like that. Sometimes there are questions about whether the person has properly waived their rights. Those factors would be more relevant in that discussion.
So there's no separate body of law that's saying how we apply those factors in the case of juveniles. There's no additional case law in the case of juveniles, how they're seeing it, whether or not they felt, someone my size standing in a high school could care less, and I wouldn't feel like I was in a custodial interrogation, versus someone who was 17 might feel they were in a custodial interrogation. How does that factor into the definition of interrogation? Custodial, excuse me.
Subjective circumstances of the person being questioned, they don't factor into that determination.
That seems absurd, I'm sorry. That's really the law?
It's correct, yeah.
I'm struggling with that mightily. Okay, I'll have to look.
Just that there are no other elements of someone's personal disposition or the attributes that they have to consider whether they're in custody. That's what you're struggling with?
Yeah, it's whether it would be a reasonable person. I mean, if the person's a retired cop who's like, leave me alone, versus a person who has never seen the law in their life and is easily intimidated, you're saying we're treating that custodial is applied equally in both cases. Then where in the test do we, it's been a long time since I did Fourth Amendment stuff, or Fifth Amendment. At what point do we factor in all of those other things when we're looking at the search, or the interrogation?
They would factor in more in the question of whether someone has properly waived those rights, which is a different question from whether there was a custodial interrogation in the first place.
Where they waived them. Well, if they were, okay, if nobody ever said to you waive them, you can say, seems to me a waiver has to say, I'm in custody and now I'm going to tell you I've waived it. You're saying, well, I didn't waive it because I didn't know I was in custody?
Well, the question would be whether there was a proper waiver.
What does proper waiver look like under this?
You want the case, I think the case that underlies this is called JDB versus North Carolina, where the court opined on this very issue.
That's what you're saying.
I haven't looked at that in I may not be presenting it exactly as it is, but
Yeah, I just thought we were discussing it on Friday. That was not the way the law came out. That wasn't how we were saying it. Otherwise, I would have done research on it. That seems odd.
As currently exists, you don't believe that that's the current law?
This is the same argument.
We had some discussions, and I thought that we were getting a different response. I mean, it's not an area of the law that I practice in, so I can't opine on that.
I mean, the debate we had last week on a custodial interrogation, my memory was whether you felt you were free to go or not. And that's where Senator West said, if you walk into a gymnasium and you tell the kid, don't go anywhere, I'm gonna ask you a question, then that would fall under the current custodial interrogation because the kid would say, I don't feel free to go. And that was the concern. But that gets back to, but if you walk in the gym and the SRO says, don't go anywhere, I'm gonna ask you questions, the kid's like running away and he grabs them, hey, don't go anywhere, I wanna talk to you about this assault. You know, I would think that would fall under, they feel they're not free to go. Especially what Senator Cassidy's saying, you're talking about a 15-year-old, you know, and an SRO's asking him questions. SRO says, and they say to the SRO, did you tell him not to go anywhere? Did you grab him when he tried to run away? I did.
So, a couple of things. I think, like we talked about before, there's a difference between an investigation and a custodial interrogation, and there's case law after case law that makes that distinction. And it's determined under a totality of those circumstances. And so, when I would personally argue, though, grabbing a law enforcement officer, grabbing someone and saying, you can't go anywhere, I want to question you, I would actually argue that it is then a custodial interrogation. But there's a difference between that investigation and when someone's actually a suspect. And I think that the language around Miranda and custodial interrogation is when the officers are asking questions intended to elicit an incriminating response. So that's not the same thing as just, can you tell us what you saw or what happened? That's not the same as an investigation. This is when someone's actually been identified as someone that is likely to be arrested or being arrested. So that's the difference. Does that make any sense? So
can I just, I mean, I'm just quoting from this decision that the vice chair just referred me to, and I mean, it was a 5-4 decision, and the majority held that it is beyond dispute that children will often feel bound to submit to police questioning when an adult in the same circumstances would feel free to leave. Seeing no reason for police officer, of course, to blind themselves to common sense reality, we hold that a child's age properly informs a Miranda custody analysis. So that's Justice Sotomayor wrote that, and it was a 5-4 decision. So I mean, it seems to me that this is a 2011 decision, and currently, you do consider it is a sliding scale, and you do say that a 17-year-old or a 16-year-old standing in the high school would feel they were in custody versus a 30-year-old standing in the high school gym would not feel they were in custody when the principal walks up. The whole case, but it seems like a pretty compelling summary. So if that's where we are with this, then this would apply that custodial interrogation, I got it, it retains its judicially determined meaning, but the judicially determined meaning since 2011 has been that when the officer walks up to the kids in the gym or the principal walks up to the kids in the gym and says, don't anybody go anywhere, they're feeling like they're in custody, and now they can't, it's a custodial interrogation. You're in custody, and so you have to stop, no more interrogation if you think there's been a crime committed, and call the lawyers, and I don't agree with Senator Carter's explanation that that you could just get one lawyer and each of the children could waive the conflict. If they can't waive their right to a lawyer, they're not old enough to waive their right to a lawyer. How are they old enough to waive the right to a conflict? I mean, if you're old enough, if you're intelligent and educated enough to waive your right to a conflict, then you're able to waive your right to an attorney. So you either can waive or you can't waive, and you can't cherry pick waivers. So you would literally have to call in, you know, in the hypothetical that Senator West gave last week, you really would have to have 12 different lawyers. They'd have to have 12 different lawyers to come in and take every kid down and wait for their 12 lawyers. I accept that they could do it by phone and not in person, possibly, but you still have to have 12 different lawyers. So it's just.
I'll tell you that lawyers represent co-defendants,
I got it.
and it's up to the lawyer to explain to the child, listen, this could be a conflict, meaning that if your defense is similar to this person's defense, there could be a conflict. And whether, it's your decision whether or not you think I can represent you both, or whether or not you want to have separate counsel. That's always going to be, I understand the kid is a kid, but I think if the lawyer explains it to the kid, just like we expect the kid to be able to understand Miranda, we can expect it, when it's properly explained to them, I think the kid can understand this when the lawyer explains it to him.
Right, so the lawyer's got to sit with each
But I'm not
client.
saying, so I don't have a problem with all the different lawyers. Like, I think people should have a right to their individual attorney. But I'm just saying, I don't think it's a given that there could never be one lawyer representing more than one person.
We were just talking about the impracticalities of this, how it plays out in the real world.
All right, let's keep it, I got it,
Yeah.
attached, but let's keep it on custody.
Sorry.
Judicially construed definition of custody. Let's just keep that, let's satisfy that and then keep moving.
We'll focus.
All right, yeah, we gotta channel our energy here, all right. All right, further discussion, Senator Sidnor, Senator West, Senator Heddleman, Senator Lee, Senator Sidnor, go ahead.
And I'm just seeking clarification. So the amendment is custodial interrogation retains its judicially determined meaning. And just to confirm, this judicially determined meaning is one that's an objective standard? I mean, that's where I'm getting confused and trying to follow the conversation.
Yeah, so I should correct. The age of the child is a factor, but, and I'm sorry for mixing that up. But also from JDB is that it's a factor because it's different from other personal characteristics, which are not a factor. So the age is a factor, but something, I think, for instance, there's a Maryland case on mental illness. Someone argued that that should be a factor in the custody determination. The court rejected that. So age is a factor, but other subjective qualities of the individual are not factors in the custody determination.
So, no, you gotta go. Just real quick, okay, you've gotta go to do your,
I just found out that staff is not permitted.
yeah. So when you get called, just,
They don't call us.
But you can get a member is calling your name. You can get somebody who's sitting up there
Just
in you.
yeah. So, go ahead.
I'm just going to move that we adopt that amendment. Do we need to adopt that amendment?
Well, so it's part of the, let's adopt the entire amendment, it's part of the entire amendment, so. Oh, we already did that last week, sorry. So we're building off the amendment. So it's already adopted. So just, I mean, we're just discussing it because it was a point of contention before.
So I don't have the language for the second part that we talked about in front of me, but we had quite a lengthy discussion about the public safety exception to Miranda and whether the language, what the language should actually be, and whether we should just say pursuant to the judicially recognized public safety exception. We talked about whether we specifically say whether there is a risk of threat to the public safety, the officer reasonably believes. There was consensus that we didn't need to use the term imminent, so Senator Castley and Huff, you should be happy about that. And the only reason is because the Supreme Court has not used it in these situations, so I can see that it doesn't have to be in there. And so, that being said, Josh, did you come up with the actual language?
Yeah, so I believe this is on page 5 of 7 of the reprint in the item beginning on line 21. So it would now read, so notwithstanding the requirements of this section, a law enforcement officer may conduct an otherwise lawful custodial interrogation of a child if the law enforcement officer reasonably believes that the information sought is necessary to protect against a threat to public safety, and, in the next item, the questions posed to the child by the law enforcement officer are limited to those questions reasonably necessary to obtain the information necessary to protect against the threat to public safety. And also discussed was the possibility of supplementing that with uncodified language at the end of the bill, essentially stating that it is the intent of the General Assembly that the term threat to public safety as used in this act be construed in a manner consistent with the judicially recognized public safety exception to the requirements of Miranda versus Arizona. The idea being that the circumstances in which this statutory exception applies should essentially be the same as those exceptions in which the public safety exception to Miranda applies.
If the uncodified language is necessary, I mean, I think the court will infer that on their own, that if we're using the same language that is used in the court decisions, that, of course, that's what we meant.
So they use slightly different language, they're not particularly consistent, so the language is kind of belts and suspenders.
Just a little.
Did I move that particular amendment that Josh just went through?
I'll second that. It's been seconded. Everyone's good? All right. First part of the amendment, you want to, did you miss the entire amendment? Was that just the second part? Two-part, both the uncodified? Okay, got it. Okay.
Threat to public
Great,
safety.
great.
And that's not in our packet.
No, that's,
You
that's.
came up with,
yeah.
okay.
Additional discussion on the bill.
So the other piece that really gives me a lot of heartache is on page 6, line 15, where it talks about the inadmissibility. It says that a statement made is inadmissible, and it has both delinquency proceeding and a criminal prosecution. I don't have any problem with the criminal prosecution language at all, but I think the delinquency proceeding, and I would make a motion to remove the delinquency proceeding from that section, simply because delinquency proceedings are there to provide the child with the services they need and to get their life back on track. And I think that we ought to, whenever possible, err on the side of getting a child's life back on track. And if the police officer messed up or not, let's get the child's life back on track and not use that as a teaching moment for the officer. So
So
that's my motion.
I don't agree with that, taking out that proceeding, Senator Casserly, because delinquency proceedings are actually still adversarial processes, and constitutional rights do really attach to them. So we're not talking about a situation that we're going to discuss in another bill that we have, which we're doing alternatives to prosecution and things like that. We're talking about an actual adversarial proceeding where the child actually does have protections, constitutional protections. So I don't agree. It's still, there's still a finding at the end of it that could be a finding of delinquency that could result in detention and then could be used in subsequent processes to up the ante in terms of what type of penalty they could get. So that's why I don't agree with it.
So just to be clear, I'm not intending by this to remove any of the existing constitutional protections. But what we're providing here is not a constitutional protection. We're providing a statutory protection. The Constitution gives you this much. We're now saying, yes, but a juvenile gets this much, where you can't talk at all. You have to have an attorney. I'm saying that for this part here, those protections, absolutely, exclusionary rule applies for both criminal and delinquency proceedings. But when we add an additional statutory protection, not a constitutional protection, for that piece of it, just for that piece alone, that the exclusionary rule would only apply to criminal proceedings and not to juvenile proceedings. So again, I'm not trying to lessen in any way constitutional protections, just that why would we want to add these additional statutory protections when our goal here was, and the evidence we were hearing was kids put in jail. These aren't kids going to jail. This is people getting what they need to turn their lives around. And I don't see where we have where our state, it's in the state's interest to not put those children in the system, and when that's what it's been determined by everybody, that's what they need. So that's why I make the motion.
Well, we're probably not going to agree.
I know.
But, so, every single case that addresses exclusionary rule talks about the reason for it is to prevent violations of the law by law enforcement violation of the rights by law enforcement, and the only remedy for that would be to exclude that evidence by which they obtained illegally in violation of the law. And so if an officer, whatever the proceeding, whether it were adult or juvenile proceeding, first of all, as we know, it could likely start in adult criminal court and then be moved back down to delinquency to juvenile court. It should apply to either proceeding. It just really should.
Sure, but remember now, the officer doesn't know where this is ending up. The officer may end, this case, this interrogation may lead, potentially to a first-degree murder charge, or first-degree rape, or first-degree arson. They don't know. Now if they don't adhere to the letter of the law, for all they know, the evidence is being excluded in a serious criminal matter. They're not out to say, oh, let's give Junior, 90 hours of community service. It's not where the officers are, that's a good thing for society. But the police are out primarily looking for serious crime. And if they don't adhere to this, and it is a serious crime, it would be excluded. And so I think that's a pretty good incentive for the law enforcement officers to adhere to exactly what we put in here, knowing that, look, if you screw this up, the best you're going to get is Junior's going to be in the juvenile court for some minor stuff, relatively minor stuff, and you will have screwed yourself on your big criminal prosecution. It seems to me that's enough to encourage police to make every effort to comply.
I thought you were trying to add some language.
No.
Okay.
No.
So anyway, I don't know, I'm going to go back and forth. Listen, the more serious the situation, the more the officer should be ensuring that the officer abides by the law and honors the constitutional right and protection of the child. And I want to just take us back to the reason that we need the bill, which we heard a lot of testimony about. Plus, we don't even need the testimony. We've seen outside of here, outside of even Maryland, that children are more often coerced into false confessions, and that they are just not equipped to handle effectively encounters and interrogations by law enforcement professionals. They are very easily coerced, and quite often, while law enforcement officers are conducting these interrogations and children are making false confessions or being coerced into statements that aren't even true a lot, it is actually a public safety risk because the actual culprits are not being pursued. And so that's why this is very important, and we should not accept delinquency proceedings. And don't forget, this action is a willful action by the law enforcement officer, okay? So it's not like, oh, I forgot to do this. It's their job actually to know, and they have to, the language, as the chairman was reminding me, is willful language. It's not accidental. It's not negligence.
Is Senator Lee? All right. Further discussion on the bill. Was there a motion?
That's my motion.
That's a motion. Has it been seconded?
I'll second that.
All right, second. All right. We can just, we gotta hold it for when members get back for a second. Yeah, you got it.
That, first of all, we didn't hear overwhelming tenant evidence. I think that was sort of the suggestion that juveniles' rights are being trampled upon. I know that's the talking points, but that's not what we've heard, and it's not the evidence we've heard of what police are doing in 2022 in the state of Maryland. We've just not heard that. What we have heard is that, and what we do know is that all of these interrogations are now being videotaped, which is a totally new dynamic that was not even possible 2 years ago or 1 year ago, which has radically changed the entire dynamic, so that the fact finder, when the defendant says, oh, this was a coerced or I was not properly Mirandized, for the first time in history, they're all videotaped, and the fact finder just says, let me see the tape. I'm going to watch the tape. You all just shut up. It's totally the tape. The tape's the whole story, and they watch the tape, and boom, it's there. So we're now moving. Here we are in a time where we've got rampant juvenile crime, despite what the Secretary of Juvenile Services might choose to believe or profess. We're in a period of rampant juvenile crime, violent crime, and the last thing we need is for police officers stepping back from interactions with juveniles. That would be exactly the wrong way to go. That there's enough juvenile blood on the streets already in the state of Maryland, and God forbid we should do anything to exacerbate that and put even more 16-year-old blood on the streets of the state. It's already a travesty and immoral what's happening. And to me, when I see a bill that says let's pull police, let's further retard police juvenile interactions. And because, hey, a kid might end up, maybe if we don't do this, some kid might end up doing too much community service that they would otherwise do, or something like that. I just find that preposterous. I think this is the entire bill's the wrong way to go, but I think certainly this amendment would at least alleviate some of that so that we're at least getting these kids into the services they need to try to turn their lives around, and to deny the child of those services that the experts would testify they need in the interest of saying, well, the police officer should have done something else. I just find that beyond my comprehension. We need to bring some peace to the juveniles in this state, because right now it's a bloodbath and of epic proportions, and we're certainly sending the wrong message with this bill, and I'd ask you to support the amendment. Thank you.
Amendment, it's been seconded, so we're going to run it. But I would like for folks to be here, so. I don't think so, but I would like Senator Lee to be here. Real quick. Senator, yes, we're on child interrogations bill still, so we're on page 6. So Senator Castley has made an amendment to remove delinquency proceeding from line 15 on page 6. So you see it's a two-part thing, delinquency proceeding or criminal prosecution. And if you follow down, the key phrase is willfully failed to comply. So there's been a motion for favorable, it's been seconded. We've only recorded one vote. Senator Huff was yes for the amendment. We're doing a roll call, so. Amendment to do that. I'm going to vote against the amendment, but, so we're going to roll call.
And it's for favorable to delete.
Correct, so I'm voting no on the favorable.
Vice Chair Waldstreicher.
No.
Senator Lee.
No.
Senator Cassidy.
Yes.
Senator Heddleman.
No.
Senator West. Oh. Senator Sidnor.
No.
Senator Watson.
No.
Senator Bailey.
Yes.
Senator Carter.
No.
Chairman Smith.
No on the favorable for that amendment. The amendment fails. All right. Now the bill's before you as amended. There's been a bill, there's been a motion for favorable. It's been properly seconded by Senator Sidnor. Actually, hold on. Senator Lee would like to be added as a co-sponsor. Senator Sidnor would like to be on. Senator Heddleman would like to be added on. Senator Walstreich would like to be on. I would like to be on. Senator Watson, what say you, my good man? All right, you're on. Well, well. All right, all right. It's been seconded. Sidnor's on, yep.
Smith. And
All the
Watson.
Dems, right?
All of them, yeah. So let's do roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
No, and just briefly explaining, I think it's fairly unfortunate that this is one of those bills that, in the spirit of let's do something really wild to get people stirred up, it's totally misplaced. It's a solution looking for a problem, and unfortunately, like we did last year for the policing bills we did last year, is going to result in an increase in the deaths of children throughout this state as more and more juveniles are shot and killed due to a lack of police interaction. And I think if that's a measure of success, it's sort of warped. So thank you. No.
Senator Heddleman.
Yes.
Senator West. Oh, he's not, sorry. Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff. Chairman Smith.
Yes. Let's do this. We'll recess right now because we got four members that have to get up to exec noms, and we'll see how long that takes. We may come back to do Senate Bill, to discuss Senate Bill 691. Yes, Senator Carter.
We have Black Caucus.
Got it. All right. Look, that'll probably wrap it for today then. So we'll come back tomorrow to vote. All right. So we're done.